Welcome to State of the State. I'm Darlene and I'm in conversation with Richard Sinapi. He's the principal attorney at Sinapi Law Associates. He's here to speak with me about the proposed Rhode Island Civil Rights Enforcement Act. Welcome. Welcome back.
Thank you. Great to be here, Darlene.
Thank you.
Timely topic.
Timely topic. Why is it timely?
Well, as a result of Supreme Court and federal court decisions beginning 26 years ago in Bandoni, unknown to most people, all our state constitutional rights have been rendered unenforceable because they're deemed to be non-self-executing. So right now, as we speak, your state constitutional rights are only aspirational or mere suggestions. And this includes significant rights. We're talking free speech, the right to freely assemble, the right to be free from unreasonable search and seizures, the right to be free from cruel and unusual punishment, due process, equal protection. All those have been found by, again, a series of court decisions over the past 26 years to be unenforceable. So despite the fact that all these rights were established by the people at referenda, including the 1842 Constitution and subsequent amendments, we have no enforceable rights unless the General Assembly enacts enabling legislation.
That's very interesting. Okay, and so this Enforcement Act did not pass.
Right, it was first introduced in 2024, that's correct.
Okay, what happened there?
It's not unusual for a bill, especially one that seeks to establish, rights, not rights, it seeks to establish an enforcement mechanism. It percolates a little bit. It takes a year for people to get accustomed to it and to get acclimated to it. To be honest with you, you can check all the records, you can check the recordings of the testimony. You can see the submissions. There was no opposition to this bill by anyone that I know of, either publicly or even behind the scenes privately. I think it's just one of those things that fell to the crack, and so we're geared up for this year.
Okay, do you want to tell us about some of the, so what did happen in Supreme Court or court that kind of led us to this place? Some decisions? Do you want to review some of those decisions maybe that?
Well, I think it might be more helpful for people to understand, why do we need it?
Okay,
why do we have, why do we need to enforce our, Rhode Island civil rights? Mm-hmm. I mean, don't we have parallel federal rights? Well, that's true to a certain extent, but Rhode Island has certain constitutional protections that federal law does not have. For instance, rights to the shoreline and to fishery. The rights of victims of crime. Neither one of those are in the federal Constitution, just to name two. So you could not use the federal enforcement mechanism, which is 42 U.S. Code 1983, which is the mechanism for enforcing your federal constitutional rights. Additionally, Rhode Island has greater protections for certain fundamental liberties, like freedom from unreasonable search and seizure. The state of Rhode Island prohibits sobriety checkpoints, random sobriety checkpoints without any suspicion or probable cause. If you say, for instance, were in line at a sobriety checkpoint for like 45 minutes, you get stopped, you get questioned, and you say, hey, you can't do that. That's against my constitutional rights. Yeah, but we did it. See you later. Have a good day. There's no remedy. There is no redress for what happened to you. Wow. That's a for instance. Mm-hmm. You can't go to federal court because that's not a protection. Sobriety checkpoints are legal under federal law. There's a third reason. The third reason is that 42 U.S. Code 1983, the federal enforcement mechanism, by its wording only applies to violations by persons acting under color of law, that is, governmental actors acting at the behest or under the imprimatur of the government. It doesn't apply to the federal government at all, or the federal agents. It doesn't apply to state or its municipalities, but it doesn't apply to the state at all, and it only applies to the municipalities if there is a violation of a policy or custom or an actual law that caused the individual's rights to be violated. So it has some significant limitations. The third reason is that, not the third reason, the additional reason is that qualified immunity. Qualified immunity protects individuals who are liable under Section 1983, but it protects them unless the constitutional right was clearly established. Seems fair.
What is, yeah.
Seems fair. The problem is the way that doctrine has evolved. For a right to be deemed clearly established, you have to find a cite to a court decision that had almost identical facts cited for the decided on the same proposition establishing that right. So as a result, frequently there is a violation of rights, but there's no remedy because it wasn't, quote, clearly established. But it's worse than that. It's not just one bite at the apple. Okay, people now know in the future it's clearly established. The way the doctrine is involved is that the Supreme Court has said, when you determine that the right wasn't clearly established, you don't even have to get to the fact of whether or not there was a constitutional violation. So that means you don't get just one bite at the apple, you get numerous bites at the apple because it's never determined whether it is a violation of constitutional rights. If that seems a little bizarre, it is, but that's the law. And I'll give you a perfect example of why qualified immunity in this situation is bad. In the Third Circuit, which encompasses like Pennsylvania, New Jersey, and Virginia and Delaware, that part of the country, they're in the federal court called the Third Circuit. Individuals were getting arrested and prosecuted. Cases always get dismissed eventually for recording police in the public, police activity in the public. And they would, say, hey, and they would, after the case got dismissed and they got arrested and processed and all that, they'd say, it's a violation of my First Amendment right. They went to the courts. The court said, it's not clearly established, so qualified immunity, you can't recover. There is no remedy for what happened to you. That went on for 10 years.
So
10 years, let me finish.
Okay.
10 years, people were arrested, subject to prosecution, always dismissed pretty much, because they weren't bothering anybody. They were just recording. There was no remedy until the Third Circuit finally said, enough is enough. This is a violation of the First Amendment. So they clearly established the right, and that finally ended it. But that's an example of the absurdity of the way that doctrine has been applied.
I'm confused about what they were arrested for initially.
Recording the police.
Is that against the law?
I think they put it under disturbing the peace or something like that.
I see, okay. And then those cases are eventually dismissed.
Of course, because...
But 10 years of that before the why 10 years? Do we know?
You'd have to find out what was going on in the Third Circuit. I don't know.
Is stuff like that going on in Rhode Island?
From time to time, yes, because it's not always a clearly established right. I can give you I can give you some example. We have a case where I'm going to fictionalize this case. It's not going to be exactly.
Sure, yeah.
Where an inmate in the state prison was in distress, in pain after an operation, and reported to sick call. Told by the correctional officer, no, there's no sick call today. I said, no, but I'm in a lot of pain. I just had an operation. There's no sick call. I'm just the messenger. He would then go to the med line, and he would complain to the nurses who are dispensing, medications. And the nurses got a big line of inmates, doing her job, saying, look, there's no sick call today. I can't help you. And that inmate, again, I'm fictionalizing a little bit, over a course of 5 days, finally got somebody to listen to him and was taken to the hospital. And he had a serious injury. Could have been killed. Just say, for instance, what would happen in that context? Well, the correctional officer, I've got qualified immunity. I'm not a doctor. I'm just doing what I'm told, right? The nurse is saying, well, I am a medical provider, but I'm doing my job, and it wasn't my job to do sick call. That was somebody else's. It's not my responsibility. So what do? We sue. Well, we got to sue the hospital. Yeah, the state. We can't sue the state. State's not a person under 1983. So that person's right to be free from cruel and unusual punishment, which in this case is the denial of medical services, can't be vindicated. So that's where qualified immunity could apply. Now, whether or not they would find qualified immunity in that case, I don't know. But I'm just telling you the examples where it could apply. The examples where, again, an individual's qualified immunity denies remedies against the individual. The way 1983 is worded, you can't go against the state. So systemic violation, which are probably the worst, okay, like that, cannot be remedied under the existing system under 1983 in qualified immunity. Okay. So what this does, what the bill does, fundamentally, it's very simple. It says that the state or its subdivisions, municipalities, what have you, are legally liable where there's a violation of the constitutional rights of an individual that was caused by acts or omissions of its actors, of its agents. Very simple. Very simple. And by putting the responsibility on the individuals responsible for hiring, training, disciplining, supervising, what do? You do two things. One is you deter future conduct because there's a consequence for it now. There's a consequence. And you put that burden on the entity that can correct it. The entity that can correct it is the state or its municipality. They bear the responsibility for it. They bear the responsibility for providing the compensation and whatever remedies are required. So that's the premise, that's the purpose, and that's how it's supposed to work.
Yeah, well, what inspired you? What inspired you to go into law, and then what inspired you to work on this act?
Inspired me to go into laws because I was always intrigued since I was little about politics and making laws and being a lawmaker. That's originally, I wanted to get into politics, be an elected official, make policy, and make the world a better place. Didn't really go that way, but I found a second calling in trying to protect and vindicate individuals, civil rights, and protect everybody's right and freedoms. Yeah.
So when did this come to your attention, and then what inspired you to put together this proposal, right?
Well, again, it's over the course of the past 26 years. Now, originally, before the Biondoni decision, and even afterwards, it was assumed that there's an implied right of action. So even though there wasn't like any enabling act saying, well, these are your remedies and you get compensation if your constitutional rights are violated, it was assumed there was an applied right of action. As these court decisions came down, it wasn't just victims of crime, which was kind of a new type of right. It was rights that are well established, like freedom of speech, freedom of assembly, unreasonable search and seizure. Those rights, aren't they self-executing? Don't we know what they mean? But the Supreme Court was very clear. Not only are we going to know what they mean, it's going to be established as a right, which they are in the Constitution, but there has to be a mechanism or means for remedies and redress. And that's where it's lacking. So as the court started saying, hey, this isn't just Biondoni, it's not just for victims of crime, all these rights we find are also not self-executing. So over the period of time, we've been left with no constitutional rights to vindicate. That's what prompted it. Okay.
And we have 15 minutes. So what direction do you want to take this in, Mr. Sinapi? Do other states have such laws?
Well, that's a great question. 23 other states either have an enabling statute, like the Rhode Island Civil Rights Enforcement Act, or they have an implied right of action, which says you have a right to proceed in a civil action for compensation and remedies for a violation of your rights. Rhode Island's no longer one of them. We were, and then the implied right of action has solely dissipated, as I said.
Yeah. Why might it not pass? So it did not, right? It seems stuck.
Well, why it might not pass is, as I said, it was a new bill, and it was not a priority among leadership to move that bill at that time.
Right, but how do we move it? How do we get the wheels turning again, so to speak?
That's an excellent question. And again, it addresses why I believe it didn't pass, and that is to get public information out there, to let people aware of it, let people talk to their representatives, let people talk to other organizations, let organizations make their voices heard. and provide, supporting legislation and testimony at the General Assembly. I think education of the people, education of the legislators is important to achieve passage of the bill.
Okay. What's the best way to get the word out?
I don't know, social media.
Yeah?
We've had I think a blog on it for over a year.
Okay.
Social media is one way to do it. The other way is to write your senator, your state senator or representative. If you belong to an organization and your organization is so inclined and feels strongly about it, they can do a letter of support as well. Letters of support are as good as testimony at the General Assembly. But I think that that's the best way. If the people, it's the people's rights, and if they want it back, they have to take it back.
Okay. You wrote an op-ed for the Providence Journal, right?
Yes, yes, I did.
Yeah, and that was published
It was
in the spring?
It was published. It was published probably in the spring, just before the legislature closed.
Okay.
And I think it was published electronically only. But it was timely because it was just before the legislature was closing and they were looking at bills at the last minute.
Okay. You gonna do something like that again?
An op-ed?
Yeah.
Of course. I mean,
Okay.
from my standpoint, what I'm going to do is I'm going to continue doing things like this, which is, public presentations and media broadcast of the situation. I'm going to do op-eds. We're reaching out to a lot of different organizations, unions, organized labor, as well, educating them on it and asking for their support and their member support.
Okay. Do you want to read through, or do you want to point out any highlights, anything that we've missed?
Well, I think that it's important that we understand that, one, the people have spoken. These are their constitutional rights and protections. I think, two, what is the premise of the bill? The premise of the bill is set forth, again, what the people said in Article 1, Section 5 of our Constitution. Every right shall have a remedy. And the principle on which the remedies are based is that as between an innocent party and the state, it is the state that should bear the harm caused to the innocent party, not the individual. There should be a remedy. There should be compensation to that individual. And the follow-up component of it is deterrence. As I said, this will deter further violations, but it's incentive to what? As I said earlier, to careful when you hire, train properly, supervise properly, discipline properly. Why? Because there's a consequence, there's accountability if you do not comply and safeguards people's rights. If you violate their rights, there will be accountability. And that's simply how it's based, and that is its purpose.
Yeah. I think I'm just having a hard time wrapping my head around that there is no recourse right now.
I mean, you can raise like the Fourth Amendment or First Amendment maybe in the context of a criminal prosecution as a shield, as a defense, but you can't get any compensation, any remedies, any restraining order, any declaratory relief. No mechanism has been provided for it. So that's true. Now, again, you do have federal rights which are parallel, and I told you you do have some recourse, but there are, as I said, there are loopholes and inability to use that 42 U.S. Code 1983 to seek remedies for your rights. So.
Yeah. So you rattled off a few of our constitutional rights, right? What else is specific to Rhode Island?
Oh, you're really testing me, aren't you? I know, well, I said one, every right shall have a remedy. I think that there's one about all public officials shall, behave in good behavior and have the utmost integrity and support for the law. But I can't remember. Okay, well, there's a few others that are not that earth-shattering.
Yeah, but where do we go to learn about our rights?
Where do we go? Well, you could read the Rhode Island Constitution, but it may not be too enlightening because without understanding the interpretation and application of some of these, so you may not know.
Where can we go where it's digestible, where it's understandable and digestible?
I didn't really prepare for that today, but I will say I think that you can search the internet and find any information in the entire world on the internet.
Okay.
Just be careful. You search multiple sources that are reputable. But there's an immense, and there's many attorneys that do blogs on this, which can be very helpful. And a lot of their blogs are in common speak. You know what I mean? So it's easy to understand. They're not some technical jargon, which you might otherwise find if you search in that fashion. But that to me would be the best way to do it.
Okay. So as we come down to 5 minutes, so what direction again do you want to take this in? What have we not covered? What's really important for our audience to know?
Well, I think that it's important to know that the remedies that it provides. It provides obviously for monetary compensation. It provides for declaratory injunctive relief, provides for punitive damage in certain situations, and also it provides for attorney's fees. And all those remedies are significant and necessary if you're going to have an effective enforcement mechanism to safeguard and protect civil rights and civil liberties. And the fee shifting is very important because very often, let's take the example I gave about you, Darlene, being stuck at the sobriety checkpoint, okay, and having your rights violated, okay? Are you going to hire an attorney and pay them to go out and vindicate your rights without any, and have to pay that attorney and then seek damages?
I would think that that's what would have to happen.
Your attorney's fees may exceed your damages. You weren't physically injured, you were delayed for a period of time. Very often, vindicating civil rights is not a monetary gain, and it doesn't, and people aren't incentivized to get an attorney in that situation. Many civil rights are hard to quantify, as to the value, but they are important. Your time is important. Just vindicating your rights and that you can't do this again, okay, is important. But again, without fee shifting, it becomes very difficult to have an effective enforcement mechanism.
So where would the funding come from then to pay for an attorney?
You have to pay for yourself unless you have fee shifting. 42 U.S. Code does have fee shifting, which is good.
Okay, so but I'm confused. I guess does that come from the state budget?
No.
No, so that comes out of my pocket.
It comes out of the only if you prevail will it be fee shifting. You have to prevail. So you would have to prevail in your claim on the sobriety checkpoint in order to get your attorney's fees reimbursed and to get any monetary damages or other remedies for the harm that you sustained.
And that'd be from the state?
Whatever the responsible party would be. Could be a municipality, could be the state, that's correct.
Oh, so it could be a private party. I'm sorry, you said it could be a private.
No.
Okay, it has to be a state.
Could be a municipality.
A municipality.
Or the state.
Or the state.
Okay.
Got it.
You can also seek, the governmental actor can also be held liable, but the governmental actors in the Rhode Island law are all subject to identification by their employers, so they're protected.
Yeah, but you bring up something very interesting is what is the value? Say on my time or, right? Who's determining that?
Well, a jury ultimately would determine it, but my point is that all these mechanisms, monetary compensation, the declaratory injunctive relief, including restraining orders or what have you, and injunctions from similar conduct in the future, as well as fee shifting is important in having an effective enforcement mechanism. And 1983 is a very effective enforcement mechanism, as I said, but it has its limitations, and it doesn't apply to state constitutional rights.
Yeah. All right, so what's next then?
I think that, it's really up to the General Assembly leadership at this point.
Yeah.
They hold the keys to protection of our civil rights and liberties at this point. And I'm hopeful that they're going to be persuaded. The bill this year is I anticipate that Robert Craven, the chair of the House Judiciary Committee, will be the sponsor in the House this year, and that Jake Basilian in the Senate. Jake was a former, I think, chief of staff with President Ruggiero, and I think he's held in high esteem by the president. And I think those two legislators who have, I think, are held in high esteem and have a lot of experience in the General Assembly, I think can help move this bill along and provide the education to everyone, to their fellow legislators, and to leadership why this bill is important.
Okay. All right. What's next for you? Do you think you're going to go back into politics?
I'm not dead yet, so anything can happen.
Okay. Anything else before we wrap up?
No, I think we pretty much covered it.
Yeah, and I think you were very clear about what we need to do, right? So do some letter writing, right? Get in touch with the people that can hear our voices, right? Social media.
It's really easy nowadays. You don't have to write a letter and post it and what have you.
Yeah.
Just send an email.
Yeah.
Emails are fine.
Yeah.
Your legislatures read them. They do.
Okay.
They read them, they take them into account, they categorize them by bills, and they look at them. So let your voice be heard.
Yeah.
I mean, I think they're going to listen if there's a groundswell of people saying, look, we want a mechanism to enforce our state constitutional rights. We don't think they should be mere suggestions and just aspirational ideals, then I think they're going to be heard.
Yeah. All right. Yeah, and I think you were very clear about why we need this. We need to see this through, right? So I'm Darlene DeRezzo. Thank you for watching. We've had Richard Sinapi on. Please find us on social media. We have a new Instagram account that's @StateOfTheStateRI.